This case moves fast, and the stakes are high. A Michigan high school teacher stands accused of assaulting a 14-year-old student, with prosecutors saying the entire incident is on video and that the teacher himself admitted he snapped. Today's hearing isn't the trial. It's about bond and next steps, but bond battles often preview the whole case. Watch for 3 pressure points. First, the defense leans on a clean record, strong family support, and argues sentencing guidelines would point to probation, not prison. Second, the prosecution says the conduct was Brazana choke with a sweatshirt sleeve, stopped only when 2 teachers intervened in, the defendant's own words will haunt him. Third, the judge, focused, skeptical, and very aware of community risk, will break down what intermediate sanction really means, why it matters or doesn't at a bond hearing, and how video plus admission can overpower mitigation. As you watch, ask yourself, if the allegations are on video and involve a minor, should bond go down just because there's no prior record, or does community safety tip the scale? Keep an eye on every interruption. Judges don't cut in for nothing and don't miss the end. A sharp ruling, a firm tone when I'm done, and a clear message about courtroom control. Let's get into it.
Everything here.
Mr. Smith, once you get to the podium, could you please state your name for the record?
Joshua Smith. Thank you.
Your Honor, today is the date and time set for a PCC in this matter. We would be asking for an adjournment of the PCC to complete discovery in this matter. I have gotten some initial discovery, but I believe there is more coming after speaking with Madam Prosecutor.
Is this the only thing holding it?
I'm sorry, Your Honor.
Is the only thing holding him?
Yes, it is.
Yes, it is, Your Honor. And we would like to address the matter of bond when the court is ready.
Cause conference July 11th,
July 11th.
2024, 9 a.m. Or as your invite indicates.
Thank you, Your Honor.
We're shifting from scheduling to bond, where the court weighs 2 big questions. Will the defendant return to court? And is the community safe if he's released? Defense is signaling classic mitigation: no priors, local ties, employment history, and family support. Those are meaningful, especially the detail that his family put up retirement funds for counsel, which underscores commitment to appear. But bond isn't sympathy. It's risk management. Expect the judge to look for concrete safeguards: cash amount, potential tether, residence restrictions, and strict no contact with the alleged victim or school. Engagement check. In cases with strong community ties but serious allegations involving a minor, what weighs more for roots or risk?
Address the matter of bond, Judge.
You may.
Your Honor, Mr. Smith has no prior convictions other than possibly a driving while license suspension case. I did run his iChat and it was completely clean. He's been incarcerated for 9 days since June 18th. He has retained counsel and is serious about facing the matters in front of him. He's a 30-year-old man that lives in Ypsilanti and has an apartment he's prepared to go home to. He's a lifelong resident of the Metro Detroit area, growing up in Canton and graduating from Plymouth High School in 2013. He has extremely strong family support in this matter. His mom, dad, and sister all live in Canton, and his extended family out of the state has been calling to...
Defense is stacking mitigation: lifelong resident, stable housing, consistent work since high school, and immediate steps toward therapy. In bond arguments, therapy appointments matter. They show insight and a plan to manage triggers. The no injury documented note from the police report is also strategic. It chips at danger and severity. But here's the nuance: lack of recorded medical treatment doesn't erase strangulation allegations, which courts often view as inherently dangerous because it can cause internal harm without dramatic visible injuries. Viewers, would you factor no documented injury heavily, or does the alleged method choke with a sleeve override that?
Check in on Mr. Smith and help in any way they can. His mom is a assistant deputy director of field operations for the Michigan Department of Correction, essentially in charge of supervising parole and probation, or parolees and probationers. His dad is a retired worker from DTE Energy. His parents have borrowed from their retirement in order to retain counsel on his behalf. Speaking to Mr. Smith's work background, he's obviously resigned from his job due to this case, but he has been consistently employed since his senior year of high school, working in various industries like food service, manufacturing, trucking, and hospitality. He is confident that he can become employed should he be released in this matter, and he does believe he has a lead on a case or on a job to become a janitor. I have had a chance to review the police report in this matter. Judge. And I would note that there's no mention of any injury to the complaining witness or no mention of any medical treatment. And based on that police report, I've done a preliminary run of his sentencing guidelines, and assuming for the sake of this bond argument only, that if he were convicted of assault with intent to do great bodily harm and he were given points under OV3 for bodily injury requiring medical treatment, maximum points for psychological injury to the victim, and maximum points for exploitation of a vulnerable victim, his sentencing range would still be 0 to 17 months, meaning it would be an intermediate sanction since it's an under 18-month sanction. And as this court is well aware, jail is not an intermediate sanction. So that presumptively this would be a
Great catch by the judge. The defense is invoking sentencing guidelines, arguing an intermediate sanction range 0 to 17 months. That often means probation. But guidelines govern sentencing after conviction, not pretrial, bond. At bond, courts consider probable cause posture, weight of the evidence, seriousness, danger, and flight risk. So even if the eventual sentence might be probationary, a judge can still hold a higher bond if present risk is real. Translation: even if you'd likely get probation later, the court doesn't have to treat you as low risk now. Legal insight: don't conflate post-verdict outcomes with pre-trial risk calculus, different timelines.
probation
I
sentence.
understand how
even if
sentencing
convicted.
works. Go ahead, get to your end of your argument.
Okay, concluding, Your Honor, I would note that there was 14 days between the arrest and the incident in this matter where there were no allegations of wrongdoing. Mr. Smith was proactive in looking out and getting a booked therapy appointment, which he would like to get back to.
Here's the defense's concrete request: $2,500. 10%, that's $250 to post, assuming a straight 10% provision. Courts often balance affordability with assurance: low enough to be postable, high enough to sting if forfeited. Expect debate over tailored conditions: GPS tether, home confinement, no school grounds, no contact with the student, mandatory counseling. But the elephant in the room is alleged strangulation of a minor. Even without documented medical treatment, the ACT plus context teacher-student turns this from a typical assault bond talk into a community trust issue. Quick poll: would you be comfortable with a low cash bond if a strict tether is added?
We'd be asking for a cash bond that Mr. Smith can afford because we do not believe he is a danger to the community or a flight risk. We'd ask for a $2,500 10% cash bond in this matter, Judge.
Response.
Your Honor, we originally requested a $75,000 cash as surety in this case, and we were given $75,000 with 10% privilege. This is a case that was completely captured on video. The defendant is a teacher at was a teacher at Ypsilanti High School.
This is the pivot. Prosecutors anchor on video evidence and position of trust. A teacher and a 14-year-old. That pairing triggers heightened concern in bond evaluations because it touches school safety and power dynamics. Also note the starting point: $75,000 with 10% originally. When the state can point to objective footage, judges tend to credit the weight of evidence factor more heavily. The state doesn't need to prove the case today. It only needs to show that the allegations are credible and serious. For viewers, how much does alleged misconduct by an educator shift your tolerance for reduced bond?
The victim in this case was a 14-year-old student. Here, the victim and the defendant appear to have gotten into a verbal argument. At one point, the defendant instructed the victim to do push-ups. The victim told the defendant that he was unable to do so because he had a wrist injury. And then at that point, the defendant got in the 14-year-old's face and said, "That's some bitch ass shit." The defendant then followed the victim as he started to walk away. And at that point, he strangles him for several seconds with the sleeve of his sweatshirt. It was only when two teachers walked.
The description matters. Verbal dispute escalates. Student walks away. Defendant follows and strangles for several seconds, using a sweatshirt sleeve stopped only by two intervening teachers. Legally, that evokes elements consistent with assault by strangulation or assault with intent to do great bodily harm, depending on charging decisions. Why courts treat strangulation seriously: it can cause hypoxia, vascular damage, or latent injuries without dramatic external signs. Even absent art records, the method signals danger. In bond terms, a sustained choke and pursuit behavior can indicate impulsivity and continuing risk, especially in a school setting. Question: Does the intervention by staff make you feel safer or more alarmed because it had to be stopped?
Walked up and intervened that this concluded. The whole thing is on victim, or is on video. And aside from the physical acts of the defendant, what is extremely concerning is that in his own words, in his statement to law enforcement, when asked what happened, he said he had a headache and he snapped and he knew it wasn't right. So I'm significant.
Admissions are powerful. I snapped concedes loss of control. I knew it wasn't right concedes awareness. For Bond, this isn't a confession to the legal elements, but it bolsters the prosecution's narrative about danger and state of mind. Defense might reframe this as remorse and insight, especially coupled with therapy steps. But in pretrial calculus, judges often ask, if stress plus headache led to a choke in a school hallway, what stops another snap? Conditions like tether, home residence, no school campuses, and mental health compliance can mitigate, but an admission makes it harder to argue the risk is purely speculative.
Significantly concerned based off of the nature of the physical acts, which were all caught on video, but also the defendant's own admissions here about what exactly happened.
May I have a brief rebuttal, Your Honor? Even with the
There was
series,
a 14-year-old, he was a teacher, and there was a strangulation.
those are the allegations, Your Honor.
Yeah,
And
go ahead with your response.
even with the seriousness of these allegations, we fully recognize the seriousness. I think the
Smart defense, move, point to the 14-day gap between incident and arrest with no further allegations. That argues stability under stress and suggests risk can be managed. They also float tether and cash. Bond, the court loves specifics. Still, remember the judge's earlier signal. Guidelines does not equal bond. To land a reduction, defense must shift the risk lens. For example, propose verified residence, third-party custodian, like a parent, employment plan, and therapy verification. Audience prompt. If you were the judge, would a GPS tether plus residence? At mother's home plus strict no contact.
guideline argument remains that this still is a presumptive probation. And I think to the danger of the community, I think the 14 days between arrest or between the incident and arrest where there was no court order in place, where there's no allegations of wrongdoing, speak to the danger of the community that Mr. Smith is. And I believe that that danger can be mitigated with reasonable terms of bonds, such as possibly a tether or a cash bond that he may afford, which we would ask for 2,500, 10%, Your Honor.
There's a 75,000, 10% bond.
I understand, Judge.
This is the fulcrum. The judge signals the facts could justify an even higher bond, then declines to raise it but denies the defense reduction. That's classic middle path discretion. Acknowledge seriousness and weight of evidence while keeping the original bail intact. Translation for viewers. The court perceives non-trivial danger. Existing bond stays as a risk buffer. Practice tip. When a judge says they could go higher, take it seriously. The court is telegraphing concerns about community safety and credibility of the state's proffer video plus admission. Key learning. Sometimes a no is also a guardrail against a worse yes.
They didn't request that I raise it. I actually should raise it, given what I've heard. I will not. However, your motion for bond reduction is denied.
Your Honor, would you consider release if he was to live at his mother's house rather than by himself in Ypsilanti as a condition of bond?
Did I thought I ordered something.
I was just asking if it would sway your decision at all, Your Honor.
Tone matters. Defense tries one last angle. Residence at mother's house as a condition. The judge's response, when I'm done, isn't just curt. It's a signal of finality and courtroom management. The court likely believes the record is fully developed for today. Strong state proffer concerning conduct and a sufficient bond already in place. Procedurally, the next milestone is the PCC date already set, where the state's discovery, posture, and defense strategy will crystallize. Engagement question. Do you prefer judges who keep bond hearings tight and decisive, or would you want more back and forth when liberty is on the line?
No, when I'm done, I'm done.
Fair enough, Judge.
Thank you.
Thank you, Your Honor.
The defense pushed hard on mitigation priors, deep community roots, therapy, and a guidelines-based view that ultimate sentencing could be probationary. The prosecution countered with video evidence, a minor victim, and the defendant's admission that he snapped. The judge drew a clear line between sentencing predictions and bond risk, declined to raise the bond but denied any reduction, and ended with firm control of the proceeding. Takeaways: at bond, danger and evidence weight can eclipse clean histories. Admissions amplify risk. And school-based conduct raises community trust concerns. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.